Welcome everyone to our second seminar in the series brought to you by our administrative officers across faculties at Mona and the Western Jamaica campus. We are very pleased that you can join us this afternoon for this presentation on estate management and life planning. We really wanted to answer the question, is it really too soon to write my will? As you know, there can be a lot of issues surrounding family members, friends, and colleagues when a loved one has passed. It is our aim to highlight some of the issues that come up when somebody passes away and help you to navigate those processes. So with that in mind, we thought it best to bring together the experts nationally who can do this. We have with us Ms. Sophia Levy from the Administrators General's Department. I will introduce her just in a little bit. I just want to give you a little about the format of the program. We will start with her presentation and we will go straight into questions and answers. We ask that you place your questions in the chat on Zoom. We will take them there. We will not be longer than an hour and a half. The presentation will be between 40 to 50 minutes thereabouts. So the length of the presentation will depend on the question and answers, and we certainly don't intend to go beyond an hour and a half. I ask that you mute your microphones, be cognizant of your video presence, and if you are not having good bandwidth, then we encourage you to turn off your cameras. So without further ado, let me introduce you to Ms. Sophia Levy. She is a customer service officer at the Administrators General's Department. She has been with the department for more than 30 years and has a wealth of knowledge and experience in dealing with situations involving intestate, as well as estate planning. So join me in welcoming Ms. Levy, and we look forward to her presentation. I'm sure I'm going to learn a lot, and I have no doubt that we will all be enlightened. And I wish for us a fruitful presentation where we learn how to plan going forward. Thank you, Ms. Levy. Welcome. Ms. Levy, you're muted.
Thank you very much for welcoming me. Thanks for the invitation to be with you. And as we go ahead, you can just make a note of the questions that you have, and I'll try to address them as best as I can at the end of the presentation. All right, so we're going to go right ahead. So we're going to be looking at estate planning. And usually for us here at the Administrator General's Department, when we say estate, we are talking about the value of what you own, right? A lot of times when we have clients coming into us and we ask about estate, a lot of them will say he never had land, because a lot of persons somehow identify estate with real estate, right? And so moving right ahead, what is an estate? An estate is the network of an individual, especially at death, right? That's the network of an individual, especially at death. And when we talk about network, we're talking about assets minus liability, right? So that's what you owe versus what you owe, what you own versus what you owe. All right, so when we talk about estate planning, a lot of us, we have loved ones, we have our husbands, our wives, we have our children, we have our cousins, our aunts, who we have to think about in relationship to what will happen to them when we are no longer around. And so when we talk about estate planning, we are here talking about the process of arranging during a person's life for the management and disposal of one's assets, right? So while you're alive, you have the ability to manage and to arrange the things that you own, right? And usually persons, when they talk about estate planning, they are more so talking about what happens after the person dies. But estate planning does in fact also include what will happen to us as even when we're alive, you know, as we get older, how it is that we manage that which we have, that which we have earned. All right. So there are some things that we need to that needs to be considered, and some of those include: what do I owe and who do I owe? What do I own and who do I owe? We need to look at who will take care of your affairs, and usually that person is an executor. Who do I want to get what I own? And that is usually your beneficiaries. Who will look after my children's emotional and personal well-being? And those will be your guardians. Who will protect my children's assets? And usually that's your trustee. And also, does my plan need to be updated? So when is it that you need to update your plan? Usually if you're having a new baby, you know, it's a good time to go revisit what you have done. If it is that you got married, it's important that you also revisit, all right? Because usually once an individual is married, even if you had made a will for argument's sake, when you get married, you have to make a new will, because the marriage means that the will is no longer valid. And so if you got married for argument's sake on the 10th of May, and you made your will on the 9th of May, which was a day before the wedding, after that wedding, you have to redo that will, all right? Because that will that you made before marriage is no longer valid. So very, very important to bear in mind, all right? So it's important, once we talk about estate and estate management, it's important for us to do what is referred to as a to-do list. And on our to-do list, it should be for us, we usually say it's very important for us to make a will or prepare a will. It's very important for us to look at what we own and to see how it is that we want to change or add names to these assets that we have. For argument's sake, if you have property, how is your property owned? Is it tenants in common? Is it joint ownership? Is it that your name is the only name that appears on title? On your bank accounts, is it your name alone? Do you want to add the names of your children? Do you want to add the name of a spouse? Do you want to add the name of a friend? These are some of the things that you need to bear in mind. If you have property and you know you want to give it to a child, or you want to give it to a friend, is it the best thing to do to add their names while you're alive? All of these things we have to take into consideration. Naming of beneficiaries on life insurance policies and credit unions. These are some things that we need to revisit. There are some of us who perhaps had our credit union accounts from we just started working many, many years ago, and we have not gone back to the credit union to ask them to allow us to nominate beneficiaries. Very important for you to look at all of this, to see whose name you have on it. If you have somebody's name, to see whether or not you have estate and to change it to the name of a child or a husband or a relative or a friend. You know, all of these things are things that we need to think about when we talk about planning ahead, planning, estate planning. We need to look at who it is that is going to take care of the interests of our children when we go. And one very important matter is the matter. Are you hearing me?
Yes, we're hearing you.
I'm having a feedback. I'm not sure why. All right, so funeral expense. This is something that we need to bear in mind, that we are actually responsible for our funerals. And so we need to make plans for funeral arrangements, right? Where is it that the monies are going to be coming from to facilitate my burial is very, very important. All right, remember, we're talking about a to-do list. We have to make plans as well as to how we're going to secure our documents. Are we going to put them in a safe at home? You know, it's very important that you put all your important documents in one place so that when your children, your beneficiaries, whoever it is, is having to sort your matter out, that they are able to access the documents that are needed to sort your matter out. So when we talk about putting on paper what it is that we own, what it is that we owe, whether or not we're going to write a will, which is usually advisable, you know, whether we're going to take the option of adding people's name to our assets if we own property, if we're going to add our beneficiary's name while we're alive, life insurance policies, you know, that sort of thing. So it's very important for us to re-examine and to look at what it is that we really want to do. The question is asked, what is a will? A will is sometimes called a last will and testament, and is a legal document which must be written, right? It must be in written form. This document sets forth your wishes regarding the distribution of your property upon death. And if you look to the side of the slide, you see where I have a template. And usually if you go on our website, that's the Administrator General's website, you're able to access a copy of the will form, right, free of cost, or you can purchase them in the pharmacy, or you can, a matter of fact, you can write your will on just about anything. Because for argument's sake, if you're in the hospital and you're not well, you don't have access to a will form, you can take the calendar off the wall and just write up your will. This is the last will and testament of me, Sophia Levy. I hereby give all that I own to Mary, Jane, and John. You sign it, you date it, and you have two persons witness your signature, and that's a perfectly good will. All right, very important. Now the question is asked, why should I make a will? One, your intentions can be clearly stated. You get to choose your personal representatives, that's your executors. Your executor can take charge of the assets immediately upon death. There is a shorter turnaround time for administration. You determine how your property is to be distributed and to whom. Your instructions regarding burial can be clearly stated. Now, we must bear in mind that we have a culture in Jamaica, and I'm thinking perhaps other parts of the world have it, where usually when an individual is deceased and there is a will, a lot of times persons don't necessarily like to look into the will or have anything to do with it until after burial, right? Well, that is fine, and I understand why, because, you know, these things can be, cause a lot of problems, a lot of issues within families. So I understand them wanting to get the funeral off before even looking at it. But if you have made your will and your instructions for burial is recorded in the document and nobody looks at it until after your funeral, then you will not get to what it is that you want in terms of burial. And so usually it is advisable that if you're going to be putting your instructions for burial in your will, that you say at least to a close friend, maybe to the person who you're going to be asking to act as an executor, that your wishes in relationship to burial is actually recorded in the document, right? Very important. All right, what makes a will valid? Your will should be handwritten, typewritten, computer generated, or it can be in Braille. All right, you must have the mental capacity at the time of writing the will, meaning that you should be over the age of 18 and you must be of sound mind. You must know and approve the contents of your will. So if you're unable to write and you're having somebody else do it on your behalf, it should be that it is read back to you and you agree to what is actually written in the document for it to be a valid will. You must sign the will or mark at the foot or the end of it in the presence of two witnesses who are present at the same time. And this clause is very, very important, because what we find sometimes, persons come into our offices with a will, the person has done the will, they have signed it, they have dated it, and they have one person signing as witness. No, that will is not a valid will, because in order for the will to be valid, then it must be signed by two persons who are present at the same time. So I can't do my will, ask Mr. Brown to witness my signature, and then take it over to Mr. Brown's sister and ask her to witness it, because it wouldn't be valid. Because Mr. Brown and his sister needs to be there while when I'm signing the will and dating it, because they need to witness the fact that I did it, and they need to do it together. All right, so that's very important. One of the things that we see happening sometimes as well, persons have done their will and they take the will to a justice of the peace for the justice of the peace to witness their signature, right? Nothing is wrong with a justice of the peace witnessing your signature, but the will be invalid if the justice of the peace is the only person who has witnessed your signature, because he cannot sign the document in the capacity of a justice of the peace. He signs it in the capacity of an individual. And so if he's going to be doing it, somebody else needs to do it as well. And so it's very important that two persons sign at the foot of the will to say they have seen you sign it. All right. All right, so let us look at the different clauses in a will. We have what is known as the introductory clause. And usually this is what it looks like. It says, this is the last will and testament of me. And it gives it where you're at, where you see the off here, it speaks to your address in the parish of, right? And that is the part that introduces whoever it is that's the owner of the will. And then we have what is known as a revocation clause, right? And this revocation clause speaks to the fact that all other wills, with the exception of this one that was done recently, is now revoked. All right. We have what is known as appointment of executors. And it says, I appoint Mary Jane of Blueberry Road and John Blue of Mark Lane Avenue, right? And this is where your executors are named and their addresses, of course. Now, who is it that is an executor? Who is it that's an executor? An executor is a person who distributes the property of a deceased person according to his wishes, as mentioned in his will. All right. You are free to name your spouse, an adult child, or a trusted friend or relative as your executor. It is also best to inform this person or persons beforehand, because what we find happening sometimes, persons have done a will, they are close to John Brown or they trust John Brown, and so they have named him as executor. But the first time John Brown is hearing about this is after the death of the testator. And so sometimes you find that the executor is not willing to act, right, in the capacity of executor. And so usually I say that, you know, ask the person, let them know that this is what you're going to be asking of them. All right, what's the role of an executor? The role of the executor is to secure your will, have the will probated. He's expected to collect all your assets and to settle all your debts. And he's expected to distribute your gifts based on what you have recorded in the documents. All right. We have also what is known as a residual clause. And what this clause does, it speaks to all the rest and residue of your estate. All right. So it speaks something like property which were not devised in the will, or which may have been acquired after the will was made. So if you have made your will in 2010 and you have acquired property in 2020, usually you perhaps would not have accounted for that, because I mean, you wouldn't even know perhaps that you would have been having this property. So what this clause does, everything that you have not named in the will, it takes care of it. So if you made a will and you have named, for argument's sake, your husband and child as beneficiary, right, and you have this clause there at the bottom, what you will do is add their names after the clause. So it's all the rest and residue of my estate I give to my husband Mark and my son Marcus, right? So you add their names after, and that will take care of everything else that was not listed in your will, which include perhaps your NHT contributions. A lot of times after persons die, even though they have a will, we find that they have NHT contributions, which was not covered in the will. Usually if this clause is there, then your beneficiaries don't have to worry, because this clause would have taken care of that as well. All right. Note that if no residual clause, such gifts will be distributed based on intestacy rules. All right, and we'll look at the intestacy rules in a few minutes. All right, remember when we spoke earlier, we said that a will must be signed and dated in the presence of two witnesses. And if you notice, we have said this over and over, because we find a lot of times that this is one of the errors that we see happening over and over. All right, so kindly be reminded, and this is what the area looks like. If you take one of our will forms, you will see that it has a slot for name, address, and occupation of your witness. Name, address, occupation of your witness. All right. Any person may act as a witness to your will, but it's best to choose what's known as a disinterested witness, someone who isn't a beneficiary and has no financial or personal stake in your choices. All right. And so usually if it is that you have chosen a witness and this person, for argument's sake, spouse is a beneficiary, you know, it can be problematic, because sometimes when persons are deceased, you find family members are not in agreement with sometimes even the content of the person's will. So they feel like they had a right to benefit and they weren't named as beneficiaries. And there are sometimes when matters are taken to court. And so usually I would say to us that if it is that whenever it is that we are writing our wills, that we ensure that we name persons as witnesses or have witnesses witness our signatures who are not beneficiaries and who has no interest outside of the fact that they have witnessed our signature. Very important. And what are some of the things that revokes a will? A will may be revoked by a marriage, and we spoke of that earlier. So if you get married and the date of your marriage is before, if the date of your marriage is before the will, then the will is not valid. It must be done after you are married. All right, I hope that that was clear. That sounded a little jumbled. So remember, we said that if you got married on the 10th, you can't have a will that is dated on the 5th, right? The mere fact that you have gotten married after you made the will, right, it means that you need to do your will over. All right, very important. Making another will. So if you made a will on the 10th and you have a change of heart in terms of content, you can make it over on the 11th, the 12th, the 13th, the 14th, the 15th, right? You can change your will as often as you so desire. But if it is that two wills are presented, what is looked at is the date on the will to decide which of them is the proper will. All right. A document made by the testator declaring an intention to revoke a will. So if you have made a will and your will is in St. Thomas and you're in Kingston and you have a change of heart, you can't get to where the will is, you can actually write a document that speaks to the fact that you want to have it revoked. All right. Also, once a will is torn up, burnt, destroyed in any way, then of course it's revoked. All right. When we talk about grants, whenever it is that we're talking about estate planning, usually once an individual dies, the intervention of the court is needed in terms of sorting out their affairs. So if an individual wrote a will, then once you are deceased, your executors are expected to take the will to an attorney who presents the will to the court, and the court issues what is known as a grant of probate. Now, if it is that you died and never left a will, then your beneficiaries are expected to seek the help of an attorney to apply to the court for what is known as letters of administration. So if there's a will, it's a grant of probate. If there is no will, it's grant of administration. But either way, once we are deceased and we have assets to be sorted out, the intervention of the court is needed, right? And because the court is the one who actually issues the document, which is the grant, so that your matters can be sorted. All right, so what is intestacy? Intestacy, where an individual dies without a will, it means that he or she has died in intestacy. All right, so where an individual dies and have a will, he or she dies testate, and where there's no will is intestacy. Where an individual dies without a will, It means that he or she dies in intestacy. We said that a while ago. Now, failing to properly deal with all your assets in a will is known as partial intestacy. Remember earlier we spoke about the residual clause. If it is that you have done your will and there's no residual clause in your will, and you have acquired assets after your will is done, then you have died partial. Your will is known as partial intestacy, because there would have been some assets taken care of by the will, and there are some assets that are left that are not taken care of. And so the ones that are not taken care of under the will be dealt with based on the rules of intestacy. All right, and when we talk about the rules of intestacy, where you make a will, we said that earlier, you will have the opportunity to name who you want to get what you have worked hard for. In the case where you have not written a will, then it's the laws of our country that speaks to how what you own will be shared up. So for argument's sake, if you die and you are married and you never had children, then whatever you own, 2/3 of it belongs to your spouse and 1/3 is shared for both parents, that's mother and father. Now, where you are married and have children, the law says half of what you own goes to your spouse and the other half is shared up equally for your children. Where you're married and have only one child, then 2/3 of what you own goes to your spouse and the 1/3 goes to your child. If you're not married, you don't have a common law union, then everything that you own go to your children. If you never had children, everything that you own go to your mother and father. Now, in the absence of a mother and father, in the absence of children and spouse, then all that you own goes to your brothers and sisters. In the absence of brothers and sisters, it goes to grandparents or uncles or aunts in their absence. And where you have no relatives at all, it is known as a bona vacante matter. And so those matters are dealt with by us at the Administrator General's Department, because these matters usually belong to the Crown, right? So where you have died and you have no relatives, your assets go to the government, right? And it's known as a bona vacante matter. All right. And we need to pay attention to this because there are some of us who have situations, right, that can be troubling for us. For argument's sake, if you are married and you have an estranged relationship with your spouse, I mean, the marriage never worked, you have not lived together for over 10 years, on your death, it doesn't matter whether or not you are living together or not. Once you're still legally married, that he or she is a beneficiary of your estate. So if you only had one child and you have a husband or a wife that you have not been with for many years, this husband or wife is going to get the majority of what you own, because they will get 2/3 of your assets and your child will only get 1/3, right? The only thing that changes that is if you write a will. Right? Write a will, or if it's a case where you're divorced. But once you're not divorced, then the spouse is a beneficiary. All right. And remember, now we talk about common law unions. Remember, there's a law that speaks to if you have been living together for over 5 years, that this person is now a beneficiary of your estate. Right? All they need to do is to seek the help of an attorney so that they can get the common law spouseship order. And once they have that order from the court, then they have the same rights as a spouse, all right, as a wife or as a husband. And so we need to bear those things in mind, right? Very important. All right, we spoke earlier about naming beneficiaries on assets, right? Because as you have heard, once we die, once we have assets to be sorted out, if we left a will, it's a grant of probate that we need to get. If we did not leave one, it's a grant of letters of administration. Now, these processes are costly. Usually, attorney's cost is between 4 to 8% on the gross market value of our estate. Right? So if you have an estate that is valued, for argument's sake, $10 million, your attorney's cost alone would be between 4 and 8%. And that has nothing to do with the transfer tax, stamp duty that needs to be paid, and the other miscellaneous costs that are associated. All right. If you died and you have a will, and the executor on your will is not a beneficiary, right? This executor is due a 6% commission, right? 6% of the value of your estate goes to this executor. And so for me personally, I am of the view that if I'm making a will and once my beneficiaries, for argument's sake, my children are adult children, then I name them as executors. One, they have a vested interest in the matter, and two, the 6% commission does not apply because they are beneficiaries. All right, so when we are talking about estate planning, we have to sit and look at what we have and sit and look at what's the smart way to sort our matters out, right? So that we don't waste what we have. Very, very important. What you find some persons doing, some persons purchase life insurance policies for in terms of planning, they purchase insurance policies which will help to take care of some of these fees and expenditures. Because usually with a life insurance policy, you go in with the policy and the funds are turned over. So if you name your daughter or your son, they just need to go in with their ID and policy, and the funds are turned over to them, and they have that live cash, which can help to do whether it's funeral or to take care of administrative costs or to do whatever it is that they want to do. All right. And so it's very important as we look ahead to bear in mind that we have to pay an attorney. Where there's property, there's transfer tax, stamp duty. Where there's a will, there's a 6% commission to the executor. In the absence of a will, whoever it is that administers is due a 6% commission. All right. And of course, there are other little miscellaneous costs that you need to bear in mind. Now, as it relates to this department, that's the Administrator General's department. Our department will help with an administrative process where there are minors involved. So if an individual is deceased and never left a will and have children that are under 18, this office will assist with the administration of those estates. All right. Where an individual is deceased, never had children under 18, but the value of what they own is up to 100,000 in value, then this office can assist the administrator. These are referred to as small estates, and so the laws of the country allow us to administer these estates without the services of the court, in that we don't have to apply to the court for authority to act. Once it's up to 100,000, the Administrator General's department have the ability to assist with these matters without seeking the permission of the court. Where an estate is a bona matter, we spoke about that earlier, bona vacante, where you have no relatives, that's a matter that we here will help with as well. We assist to get funds out of an institution to facilitate burial. So for argument's sake, God forbid you die tomorrow morning and you never left a will, your bank accounts have nobody's name on it but yours. Your beneficiaries can come in to us here at the Administrator General's department. We would write a letter to the financial institution to find out how much is available. And then we will do a second letter asking that funds be released to the funeral parlor to facilitate your burial. All right, that's one of the services of the department. Also, if it's a case where you are married and you have a motor vehicle and your husband is deceased and his name is the only name on the papers for the vehicle, the laws of our country recognizes that asset as a personal chattel. And so this office will facilitate the transfer once it's the only asset in the estate. If there are other assets in the estate, then you are going to have to get your attorney, apply to the court for the letters of administration since you never left a will. And that is what you would take to the tax office to facilitate the transfer of the motor car. But if it is that the only asset is the motor car being used for personal use, you can come into us and we will do the paperwork, ask the tax office to assist you with the transfer. All right, when an individual dies without a will, there are some things that are classified as personal chattel, and those include a motor vehicle, a gun, jewelry, clothes, furniture. All of those are classified as personal chattel and belong to the spouse. All right. In closing, there are some things that we should try to remember One, we must always have a basic estate plan in place, right? We must always take an inventory of our assets, look at what it is that we owe, what it is that we own. We need to discuss our plans where necessary. So for some of us who might have adult children or adults who we are naming as beneficiaries, sometimes it's good once you feel that it's safe and nobody's going to hurt you to take what you have, just to let them know that, look here, I have done a will and I've put it up in a safe place, or I've done a will and the will is wherever. We need to have this kind of discussion. Sometimes we need to take our children aside, let them know what it is that we have, what it is that needs to be done in case of an emergency. All of this is a part of planning ahead, planning for our estate, planning for our families, all right? We must do a will. Where we have assets, it's important for us to say who we want to get what we own. There are some of us who might not have spouses, we might not have children, but we have a very good friend who has been very kind to us, right? And who has always been there for us, and we want to leave something for them. We want to let them have our houses or whatever it is that we own. We need to put it in writing. There are some persons that are of the view that they can just tell the friend that when they die, they can take this or take that, but it doesn't work like that, because once you are deceased and you never had children, you never had a spouse, then whatever you own belongs to your siblings, brothers and sisters, or if in the case where your parents are alive, goes to your parents, right? And so this trusted friend who has invested a lot will not benefit based on word of mouth, right? So it's important for you to put what you're giving to whoever you're giving it to in writing. All right. We must ensure that we sign the document, sign our will, and this must be done in the presence of 2 witnesses. Very important. And we must remember that our will can be amended at any time.
All right,
Also, if you have made a will, and you want to ensure that nobody destroys it, right? It's advisable that you register it with the RGD. All right, your will can be registered with the RGD. So even if the one that you have is lost or stolen or destroyed, you can retrieve a copy from the RGD. All right, so I'm at the end of my presentation. Thank you very much. If you have any questions, we can go right ahead and let's see how best I can respond.
Thank you very much, Ms. Levy, for that very detailed presentation. I'm sure every one of us in this session, we've learned something new today. Boy, it is so important that we understand, as you said, what is it that we own?
Yes.
Who do we want to have? Well, what is it that we owe, actually?
Yes.
And what is it that we own? Very important. Who do we want to get them? And a very important point that you raised, and something that we need to consider: who will look after the mental health and well-being of our children? And that's very important. And it's important for me because I noted that you did not say financial well-being. Because mental health and the interest of the child is as important as financial well-being. So those are very, very important points to note, and very important coming from this session. Planning, 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 thinking ahead, knowing what you have, what your family dynamic is, what your situation is, and what it is that you want. So thank you. We have a number of questions. So I'm gonna just start. I mean, I'll start with 2 that might be a little controversial, and then we go into some other technical questions. A question here is it true that a person is not allowed to exclude a spouse from a will?
The truth is that you can exclude your spouse if you so desire. Usually it is, some persons are of the view that it's best to leave something, if it's even a small, anything at all, to show that you have considered your spouse, but your will is your will. I mean, your spouse have the right as well to contest it if he or she thinks that they should have been provided for under your will, or they should have been provided for much better. Because for argument's sake, you could leave a motor car for your spouse, but your spouse felt that he should have gotten half of your property. He can in fact take the matter to the court, and the court will decide whether or not, he should in fact have gotten half of the property as well. So it's your will. You can put whatever you so desire in your will. But as you have said, there are some persons that are of the view that you should leave at least something. So it will be known that you had in fact considered your spouse.
I have another question which is similar to this in a sense. So I'm a beneficiary to a will, but this will was made after marriage, long after marriage. Can the spouse cut my portion in half or dictates the amount that I get? So for example, they didn't give, but I'm just going to give an example. If I'm left with a property value in $100 million, can the spouse sell the property and then only give me 50 million or give me nothing at all?
The question is not clear because you're saying that a will was left. Who is it that left the will?
The husband left the will way after marriage.
Right. So two persons are married, and the husband is deceased, and he left a will, and he has named you as a beneficiary.
Yes, I'm not a child.
You're just a beneficiary, right? But you're saying that the spouse is the executor.
That I'm not clear. No, he's not the executor actually. She's not the executor. Somebody else is. I think his brother is the executor.
Right. So what happens, remember that once you leave a will, usually you have named an executor. And the executor has a responsibility to ensure that he follows the wishes that are laid down in the will. So it's really and truly the spouse would not have been the one who is the executor, unless it's a case where the executor has renounced his executorship and the spouse has taken the grants, because you can do that. If it is that you are a beneficiary under a will and the person who has been named to act as executor decides that he or she does not want to act, then any beneficiary under the will can apply to the court for the grants. Right now, if it is that the court has granted you the permission to administer somebody's estate, it's one of two things. You must follow the wishes where there's a will, and in the absence of a will, it's the laws of the country that states how what is shared up. So if I wrote in my will that you're to get a pen, regardless of who it is that administers, you're expected to give over the pen. If it's a case where you did not leave a will, it's the laws of the country that says who is to get what. And so regardless of who takes the grant, if it's a spouse, the spouse gets half and the other half is shared up for the children. So if it's 10 million in value, 5 million belongs to spouse, the other 5 million is shared for the 5 children, 1 million each. So you're expected to do what the law says that you're to do. Anything outside of that, you take the matter to the court and let the court enforce what needs to be enforced.
Thank you very much for that response. I have another question here. What is meant by inter vivos transfers and what is the significance?
Well, usually you can make a transfer while you're alive. So I have a property and I know that while I'm alive, I know that I need to give it to my daughter, Mary. While I'm alive, I can transfer the property to Mary.
Okay.
Right? I can transfer it while I'm alive.
Sure, thank you. Another question is, would setting up a living trust be better than a will?
I would not say that it is, right? Because it depends on what it is that you really want, right? Because when you talk about a will says everything that you want to give everybody. When you talk about a living trust, you're talking about what happens just while they are alive. But once you have passed on your gift to the person, then the person does whatever it is that they want to be done.
Sure. I hope that answers those questions.
I hope so too.
Right. Another question is, if a prenuptial agreement is made, will the marriage still revoke the will?
Prenups is really an agreement between both persons, right? To say, well, then the person will not be looking for anything, right? But once you make a will, it is important to note that based on what the Wills Act say, is that once you are remarried, you need to make your will over. So once you are remarried, you need to do the will over because it's going to be null and void, sorry. It will be invalid.
Sure. Thank you. Okay, here's another question. If real estate is held as tenants in common and transferred as a gift, should the real estate be reflected in the will as well?
If it is that you have a piece of property and you own it as tenants in common, it means that you can pass on your half via the will, right? So you can put it in the will, even if you have a property, and the property is owned as joint ownership. Remember now that joint ownership speaks to whoever it is that outlives who will end up with the property. So when you talk about joint ownership, you're talking about whoever it is that died first, the property now belongs to the other party. But there are persons who own property jointly and they still include it in your will. What we need to know is that if you include that joint property in your will and you die before the person who is the other joint owner, that the will can't, the property can be passed on via the will. But if it's a case where you have put the property in your will and your joint owner dies before you, then this property can be passed on by the will. When we talk about tenants in common, remember now tenants in common means I own my half, you own yours. If you die, you still own your half and can pass it on via a will, right? Or you can give it as a gift. So tenants in common, yes, you can pass it on via your will.
Thank you for that. This is a question. What happens if land is owned by a company and the company no longer exists?
Well, if it is that the company own property and it no longer exists, then whoever it is that has interest in that would have had to seek the help of an attorney for them to look at the paperwork and to be able to properly advise them as to what needs to happen.
Okay, thank you. Do amendments to a will need to be witnessed by two persons as well?
Usually when you amend your will, you do it over because you can't do your will and cross it out. You can't do a will and draw a line through something because you change your mind, right? That's not acceptable. You have to do it over because it's best not to have any errors on your will or any crossing out. So once you're amending, it means that you're doing the whole thing over and you're going to discard the old one. So it's usually best once you have done a new one, tear it up, burn it, throw it away, right? So you remember your will must be witnessed, right? But you can't do a will and adjust it and then have somebody sign it. That doesn't work.
Thank you very much. Suppose you have another question. Suppose you have two different wills with the same date. What then?
Well, if it is that you have two different wills with the same date, then I suppose it's a matter of going to the court, and the court deciding which one is valid. Because really and truly, it's very unlikely that you would write two will unless the two wills are saying the same thing. Because you have persons who write their will and copy it and then they sign the two wills. Now, if that's the case, then you don't have an issue because the document is the same. You understand what I'm saying? But if it's a case where the content is different, then that now means that is a matter that the court has to decide on. And so whoever your executors are perhaps would have had to go to the court for them to decide, how best to resolve the matter. I remember now that the court is the highest in terms of making decision on the island. They are the body that does that. And so whatever it is that cannot be resolved, by us just talking about dealing with it in terms of an attorney, then the court is the one who does that.
Thank you very much. This question you may have answered already, but I'll go ahead. What if you are separated for years but still married? Will my husband get 2/3 and child gets 1/3?
Definitely. And usually if you have more than one children, then your husband gets half and the other half is shared up for the children. But remember now, once it is that it's proven that the marriage, even if it's a case where you have started divorce proceedings and it was not completed, in that you did not get the decree absolute, it means that you are still married, right? And so
Yes.
even if it's not complete, your husband is a beneficiary or your wife.
This question is asking, does it matter the age of the children if your parents die without leaving a will? Or this is saying if both parents die without leaving a will, does it matter the age? It's not clear.
Okay, once an individual is deceased and did not leave a will, and there are children involved, even if it's one child that's under the age of 18 and there are assets to be resolved, then the Administrator General's Department steps in. Our mandate is to ensure that the interests of the children or the child is taken care of. We act, however, on behalf of all members of the family, right? But we only take the matters that have children involved, meaning children under 18. Why is that so? A child cannot agree to anything. They can't sign documents. They can't seek the help of an attorney, right? They can't speak on their behalf. And that's where we come in. So we are guided by the law, and we ensure that the children benefit from what their parents have left behind, you know, and that they get what they are supposed to get. So in some instances, yes, it might be one parent. In some instances, we have matters where there are both parents are deceased. And in some instances, we have both estates that are here and that are being managed by us.
Thank you very much for that response. We have a bit of a controversial question here. Well, you'll be the judge. Can you have someone else other than a lawyer present your will in the court? It's threefold. If not, can the fees for the lawyer be negotiated? 48% is excessively high, is an excessively high sum of money for what involves little or no effort by the lawyer.
Okay, all right. I can't speak for the attorneys. That's the first thing, you know, in terms of what it is that they charge you, you know, but 4%, if you have a will or you have an estate to take through the courts and they charge you 4%, that's not so bad. Yes, your fees can be negotiated with your attorney, and that's why you're the one who choose who you use. So you did have the discussion and see how much it is that this person is willing to charge you. You understand? So the getting of your attorney is your responsibility. We don't recommend attorneys, right? Because that's your purview. I mean, you have the right to do that. And so we don't do that. That's your prerogative, right? And so we would not do that. So as it relates to cost, you definitely have to discuss it. I'm not remembering what's the first part of the question. What was the first part of the question?
Can you have someone else
take the matter to the court?
Yes.
Okay. I don't think the court will turn your application down because you're not an attorney. What the court wants is the documents that are to be presented in the format that they require it to be done. And so if you have the know-how, if you know how to prepare the court documents and you present to the court what it is that they want to see, then yes, there are persons who have acted on their own and have gotten through and have had their matters sorted out. But it's just the greatest issue is having the know-how to do what needs to be done.
Okay, thank you. I have a question here. My mom's will name me and her husband as executors, and she left 50% of their house to me. My stepfather mentioned having the will probated, but has not given any updates. How can I find out the status of the probate process?
Usually, when a matter is being probated, remember the court is the one who issues the grant of probate. And so if it is that you're making an inquiry, you would have had to make an inquiry from the court. You know, unlike what a lot of persons think, this office, we don't act where there's a will. So once an individual has made a will, it doesn't come to us at all. So we are not the ones who issue the grants. The grants are actually issued by the court. And so if it's a case where you want to find out whether or not a grant is issued, then you have to speak with the court. And the court is the one who will be able to guide you as to what it is that has been done. Outside of that, the best way to do it is to actually speak to the person doing the process and hope that, they really do give you the information that you need. But the court is the one who they have to go through. And so that's where you would have had to do your inquiry.
Thank you. Another question. At what age can a child's name be added to an asset?
A child name can be added to an asset. And most time we talk about assets, talking about property or bank accounts or so on. You can add your child's name at any time. There was once upon a time when persons never really wanted to add their children's name to property because they felt that when they are old enough and want to get their benefit from NHT, that they would not be able to get their benefits. But NHT has adjusted their policies somewhat in terms of children owning names on properties and still being able to get their benefits, which is something you have to check with NHT for. But you can, in fact, add your children's name at any time. Even if they are minors, they can be added to your title.
Thank you. Another question. Can an executor change a person's will after the death in any way?
No, an executor doesn't have the right to change anything on a will. The will is the wishes of the person who actually made the will. And remember, when we spoke earlier, we spoke about a valid will and the fact that you are going to have to approve the content of your will. Now, you can't approve the content of a will when you're not around. And so the person you have elected to do the process on your behalf cannot change the content.
Thank you very much. Another technical question. If you have a property with more than one houses on it, do you show which house is being left for each child or which child? Can the house be labeled example section A or section B?
The truth is that it's amazing some of the things that persons actually write in their wills, because persons can write just about anything at all. You can write anything in your will. So if you have one house and you want the room around the back for Mary and the room at the side for John and the room at the front for somebody else, you can actually put it in your will, right? So even if you have a piece of property and you have house 1, house 2, the house in the front, the one in the middle and the one to the back you give to Mary, John and Junior, then you can do that. You understand? What we need to bear in mind is that if you have a property, a piece of land, and whatever it is that is on the land, it's one land. So when we talk about titling, unless it's a case where it can be subdivided and each person get their piece of their piece cut off and it's titled, then that might be a little different. But in a will, you can actually put just about anything you want, because remember, now it's your wishes. Right? So you can actually give or share it anyhow you want to do it.
Thank you. What if you own property in 2 different countries? Which country has jurisdiction? Must there be 2 wills, one in each country?
Okay, you don't need to write 2 wills, right? If you have, usually for argument's sake, if you have property in England and you have written your will and there's property as well in Jamaica, there are assets in Jamaica that needs to be dealt with, what you find is that you can probate the will in England and the will can be resealed here in Jamaica, right? So you can actually have it resealed here to deal with the assets that are here. So it can be probated in one jurisdiction and it is resealed in Jamaica to deal with the assets that are here in Jamaica. So you don't need to be writing more than 1 instrument. Whatever it is, you need to just record it in the 1 document and it can be dealt with. Once one set of assets are dealt with, the others can be dealt with after.
Thank you, Ms. Ramley. Just want to acknowledge that you've been basically speaking for an hour now. So we have you just for about 20 more minutes. So thank you so much. And you're answering your questions so exuberantly. Thank you. Another question. What if a will has been probated and then years after you find a later dated will? Is there anything that can be done?
Well, the truth be told, if you have probated the first will and you have actually dealt with the assets that are in the will and the assets have been distributed, if another will turns up, right, and the beneficiaries on that will is different, it is a matter for the court to decide what happens then. You understand? Because it's one of two things, that they're going to leave it be because you have dealt with that before, or if it's a case where the beneficiaries under the will that has been found feel strongly enough and they need to take the matter to the court, then I mean, it's the ball is within their court to seek the help of their attorney, to have them advise them and to have the matter presented to the court if it is that that's what they want to do.
Thank you. What? Oh, I asked that already. I will have to go through probate. Do you have an estimated cost associated with probate?
Remember, we said that it's a percentage of the value of the asset. So if it depends on how much your assets are valued, your attorney has the right to say how much it is that they're going to be charging, in order to present the matter to the court and to sort the matter out on your behalf. So that's a discussion that you would have had to have with the attorney that you have elected to do the process.
Right. There's a question here, but it's not clear to me. I'm not so sure if you can, maybe you can understand. What if a parent got married? What name should be on the will? I wonder if the word parent should be person.
Well, usually you write your will in the name of whoever, if it is that I'm Sophia Brown today, then my will is going to be in Sophia Brown. Remember now that when I get married tomorrow, I have to redo my will. And so if I get married now and I'm Sophia Levy, I'm expected to do over my will and I'm supposed to include my name. Even if I'm going to keep the Brown, it must be Sophia Brown Levy. But remember, after you get married, you have to redo the will, right? And so that can be addressed in the new will.
Thank you. What happens in the case of the death of an executor?
Okay, usually when an executor dies, you will now have to do what is known as an application to the court for letters of administration with will annexed, meaning with will presented or accompanied by the will, right? So the will is, the assets are shared up according to the will, but then somebody else is appointed to act. So if, for argument's sake, you made a will and you have named your cousin as the executor, but your cousin died, then once your will is being probated, any one of the beneficiaries under the will can take the grant. So any one of them can apply to the court for the grant of administration, and the court will use the will to say how it would be accompanied by the will to say how the assets are going to be shared. So usually when you're doing that now, you would have had to present the death certificate for the executor to prove that the executor has died. And remember, we said earlier as well that for sometimes persons are named as executor and they renounce their executorship, right? So in that case as well, any of the individuals under the will can take the grant.
Thank you. There's a question here that you did answer. Can your adult child be the executor of the will? And I recall you actually encouraged that at times.
Yes, yes.
Right. There's another question. What is the process to add a child's name to the title?
Usually, remember that titling in terms of property, all of that is done through the National Land Agency, right? And so if you want to make any adjustment to ownership on your titles for property, it is best to get in touch with the National Land Agency, because there are forms and stuff that they have there that you will need to complete in order for the process to be facilitated. So all aspects of changing of information on titles goes through that office. And so they will guide you, tell you how much it is that needs to be paid and so on for that process to be done.
Thank you. This is an example. Michael Jackson initialed and date all pages of his will. Is this recommended to ensure that this is a true will?
Yes, you're expected to sign the will at the foot of the will and to have your witnesses witness your signature. So it's usually best if your will is more than 1 pages to do the same at the foot of the document.
Thank you.
You're welcome.
What if a parent does not have a land title for the land, only receipts? Should it be mentioned in the will? Well,
yes, you can still mention it in the will, right? But then, you know, those matters are going to take a while to be sorted out, and the processes are going to be longer, because now you'd have had to go through the process of having the property perhaps registered. If it's a case where they purchased it from somebody and the person themselves is deceased, then, you know, that is going to be problematical. Usually what we find happening, especially in our country, is that sometimes persons purchase property and the process is not complete. So they purchase, they didn't go through an attorney, and so they have receipts to say that they have paid for the property, but they didn't go on to have their names added to the titles, you know, and so usually you would have had to get a lawyer to help you to sort that out.
Thank you so much. Could you?
Yeah, but
Sir, please mute that person for me. Thank you. Just to say, we're just taking up another 2 to 3 questions so we can wrap up and stick to our time frame of an hour and a half. Boy, Miss Levy has been just on the roll answering our questions. I'm thanking her in advance for that.
Oh, you're
all
welcome.
Right, next question, Miss Levy. Can someone get a lawyer overseas, since she's overseas, to deal with an estate left by her husband? There's money at NHT, private pension, bank accounts, etc.
You can get your attorney to deal with your matter. Remember now that it's really your personal choice. Usually what I recommend is that you find an attorney that works in our jurisdiction to assist you, because the laws are somewhat different, and so you will perhaps have an easier run if it is that your attorney is acquainted with the laws that applies here, right? There are some companies, however, that may have offices overseas. It is good if you have one of those companies that have Jamaican affiliations, you know, that would make it a little easier as well for you. But if your attorney is overseas and they know what they're doing and how to do what they're doing in terms of our laws, then I shouldn't see an issue. But it's usually best to have somebody here do it on your behalf.
Thank you very much. I think you basically answered this next question already. Can you be married but do a will where you leave all your assets to someone else and it is not contested? I think you said the wife can contest.
You can contest, because if it is that John and I are married and we have been married, say, even a year or whenever, and there is assets there, he owns a property for argument's sake, and that's where we live. We were married and that's where we were living. And when I look at the will, I mean, the property is left for somebody else. I can take the matter to the court and let the court decide, I mean, whether or not this person should get half of the property. Because usually, if it is that there's no will, then the day you marry, half of what the person owns is yours, unless the court says otherwise, you know, so you can contest it. You know, remember that when you make your will, your spouses can contest it. And that's why some persons are of the view that when you're doing the will, put something on it for the spouse, you know, but as I said, it's your will, you have the right to write whatever you want in it. But bear in mind, once it is that there is somebody else who feel like they have a just reason to question what you have written, then they have the legal right to take the matter to the court. As to whether or not the court will honor their wishes, that's another thing, you know, but it depends on what is presented to the court, but the court can look at the matter.
Thank you. Can you name a secondary executor?
Usually if you look at most of the will forms, they give you the option to have 2 executors. It's usually advisable to name 2 persons, just in case one person dies or in case one person don't want to act, then there's always another person, or they can both take the grant together, right? So usually it's best to name 2 executors.
Thank you very much. This is a follow-up question. You mentioned that when the executor is a beneficiary, the commission is waived.
Right.
Does this same apply if the executor is a beneficiary of an insurance policy, for example, but he or she is not explicitly mentioned in the document itself?
So you're saying if you have made a will and you did not name your executor, but then you have left an insurance policy. Remember now, you know that the 6% commission is charged for the work of the executor, right? And the executor now is responsible to take your matter to the court to get the grant. They are expected to collect all your assets and to pay your debts, right? So usually that's the function of your executor. So even if you left a gift for the executor outside of what is in your will, the executor could, depend on who the person is. There are some persons who perhaps will say, well, I got some money already, so I'm going to waive this right. I don't need it, or I should not take it, or I don't want to take it. But then you have some persons who perhaps will know that that funds is there and still take the 6% commission, right? Because if it can't be that because you have left that, then this person must not get the 6% commission, because the 6% commission is totally different from the gift that you left. So usually it's best you name, your beneficiaries as executor, or if it's a case where you have put it in the will that the person is to use that as their fee, well, it depends too, because if when the executor look at what they are getting in comparison to the percentage 6% value, they could perhaps decide otherwise, you know.
Thank you. 2 final questions. Are electronic signatures made by witnesses accepted, especially in the context of COVID-19? Suppose the person, well,
Yes,
basically saying, suppose the person is in the hospital and the preferred witnesses are physically unable to sign the document. What happens then?
Usually, once you are signing the document, all 3 of you must be in the same space. That's what the will act says, right? So the electronic signature thing might be stretching it a bit, because you're actually supposed to be in the same environment, and the wills act has not been adjusted to facilitate that. So once I am signing, I have the paper in front of me and I am signing it, then the other 2 persons should be in the room and signing at the same time. Anything outside of that can be disputed.
Okay, thank you. And noted, an important fact.
Yes.
All right. Last question. What happens if parents are deceased and the children are having the properties probated while persons are living at the property over 12 years? Can they later claim ownership, being that they're living there for so long? The children are still paying the taxes.
Usually the whole thing about adverse, I think that speaks to adverse possession, where we find persons are living on a property for over 12 years and paying the taxes and are living there undisturbed. That's what adverse possession speaks to. So remember, now it's not just living on the property, but you have to be living there for a certain period. You have to be paying the taxes and you have to be there undisturbed. And those things must be proven. So it's not just living there alone, but you must be paying. So if you're living there and somebody is paying the taxes, you can't claim it. You understand? And if you are living there and paying the taxes, but persons know that this person has an interest and they have been back and forth and whatever. So it's not a case where you're just living there and nobody ever comes there and say, well, then this is mine or anything like that, because it's well known that it's theirs and they have been coming in and out. You can't go and say, well, then you have been there undisturbed.
Okay, no problem. I did say that was the last question, but I'll just ask you this so you can speak to the Administrator General's office. Are will forms available at your office?
Yes, they are. They are online as well. They're on our website, and our website address is www.agd.gov.jm. So that's www.agd.gov.jm.
Yes.
So, or you can go there, go to forms, and you will see a set of forms. You print will forms, and that's perfect. We also do have the forms at the office. If it is that you want to swing by and retrieve one, then that's fine.
Right, just to let you know that your colleagues placed the information in the chat, so it's also there.
Okay, very good.
All right. Before I wrap up, give the vote of thanks and wrap up, I just want to make an announcement. Just to say that the Legal Aid Clinic at the Faculty of Law at the UWI Mona will accommodate or assist persons, up to 300 persons, in writing their wills. This will be done in November, sometime in November, tentatively between the 22nd to the 26th. More information will be provided. Their numbers are 927-1007 or 977-2880. So that's something I'm encouraging everyone on this discussion to look into for additional help and resources. So, Ms. Levy, you were so informative. I just want to say thank you. Thank you, thank you, thank you.
You're welcome. Thank you too.
Right. I also want to thank
Okay, thank you very much for having me. God bless you, and you can get in touch with us if you need any other question answered. All right. Take good care.
Well, I also wanted to extend thanks to Miss Teresa Ramjeet for facilitating us from your office. So thank you so much. She was always willing and able to answer our calls.
Yes, she has.
Yes. I also want to thank our organizers. Our organizers are our faculty administrative officers. We have Ms. Stephanie Pinnock from the Faculty of Law. We have Ms. Stephanie Pinnock, Faculty of Social Sciences. Ms. Peter Gay McEwan from the Faculty of Law. Okay, there we go. I'm having my PowerPoint. So here are our faculty administrators. Ms. Margaret Spence, Faculty of Engineering. Ms. Sophia Hills Johnson, Faculty of Humanities and Education. Ms. Peter Gay McEwan Lewis, Faculty of Law. Ms. Sharon Roberts, Faculty of Medical Sciences. Ms. Rosalie Simmons, Faculty of Science and Technology. Ms. Stephanie Pinnock, once again, Faculty of Social Sciences. Ms. Asnet Sharp, Faculty of Sport. And I am your host, Indiria Ajuda from the Western Jamaica campus. So I want to thank these ladies for putting on this seminar. It is the second in a series. We will be having another on financial matters coming up in June. June, yes, that's June. So thank you very much once more to our presenter, Ms. Levy, and her colleague from the Administrator General's Office, Ms. Teresa Ramjeet. I also want to thank you, our audience. Thank you for participating and staying with us throughout the entire session. Your questions were thought-provoking, and I'm happy that we were able to facilitate your answers. So have yourselves a wonderful evening. Thank you, everyone. Bye.